So you finally get the call from the insurance company, but the offer that they are giving you barely covers your medical bills. You've done absolutely everything the right way. You've documented your claim. You've documented the accident. You've even followed up, and they still won't come above this lowball offer. That makes no sense. And if you accept it without knowing what's missing, you could lose thousands, money you actually need to get your life back on track. Hi, I'm Ted Spaulding. I'm a personal injury attorney here in Georgia, and I've seen too many people settle for less because they didn't know what to push back on. This video, I'm going to walk through 5 proven ways to stop insurance companies from underpaying your claim so you can protect your case, get the payout you deserve, and avoid being taken advantage of right when you're at your most vulnerable. So let's start with the single most important thing that you can do to avoid getting lowballed by an insurance company after a car accident in Georgia. You need to gather all the evidence, as much as you possibly can from the very beginning. You cannot wait. I'm talking about right after the crash, as soon as it is safe, right at the scene. And here's what I mean by this and why it matters, okay? The insurance companies in Georgia, like everywhere else, are looking for ways to pay out as little as possible. It's their job. You have to understand that. You can hate it. I do too. I wish they would treat people better. I'd be out of a job, quite frankly. I'd have to be a criminal lawyer, as I joke, if they would just treat people fairly. But their job is to do the best they can to pay as little as possible. If your claim is missing details, there are gaps, or if you don't have the proof that you need, or even just the best proof, right, that can really drive value in your case, you're going to get lowball. And you're giving them the exact opportunity to do it, because it's not their job to get these things for you, to help you with your claim. They're not there to do that. That's what your attorney is there to do, is to help you build your claim. But you need to help yourself. So what does gathering evidence really look like in Georgia? There's a lot, all right? So let's dive into it. First, you need to pull your phone and start taking pictures right there at the scene. I'd even take video. You need to get shots from all angles, show the cars together if you can, right? Crumpled up right there at the scene. You need to look at the intersection. For what? For how it looks. It helps tell the story. It helps also fight against any kind of, hey, it wasn't his fault or it's possibly your fault. You need to talk to all of the witnesses. You need to get all their information. It's the biggest thing that drives me nuts. Oh yeah, there was 3 witnesses. All right, well, who are they? Well, they'll be on the police report. No, they aren't. I can't tell you how many times the officers do not put witnesses on police reports. It drives me crazy. And you didn't get their information, they're gone. They're gone. Nobody's got it. You got to do that for yourself. It helps you, and then it helps your attorney if you hire one. You need to take pictures of all the bruising and cuts and everything from start to finish. So day one, doesn't have to be right there at the scene, obviously, but first day, and then document it as it moves along and progresses. That really helps. It goes a long way in front of an insurance company and then ultimately a jury if you end up having to try your case. And let me go back for a minute on witnesses, right? So you've done all the pictures and everything there at the scene. Talk to the witnesses, get all their information. Georgia law does not require them to stick around forever. They're not going to. So if someone saw it, get their name, get their full contact information, address, phone number, email, and then talk with them. Have your lawyer talk to them as well. Get a statement from them. Maybe a recorded statement's really good. Because understand, insurance companies are going to try to poke holes in your story if they can. If you've got a witness that's going to back you up, that's all you need. They are a third party, has no dog in the fight, that's going to say, yeah, that other party is at fault. That's what you need. That is the best evidence, right? It goes so much further than just the officer saying it or obviously you saying it. And don't forget the police report. You got to get it. You got to call 911. Hopefully you have. I've had plenty of cases here recently where they just chose not to call the police. And then I can't tell you how many times, because you think the other party's not going to lie, they then do. Now you're in a liability fight that you shouldn't have been in. Because if the cop came out, they're required to determine who's at fault. And they're the best witness for that other than actual third-party witnesses that saw it. So please, you got to get it documented by a police officer and they will determine fault. And then you can use that against the other party. Let me give you a real world example to kind of wrap this part up for you. I had a client in Atlanta who took pictures of everything at the scene. It was great. Even the weather, broken glass all over the ground, the intersection. When the insurance adjuster tried to claim her damage wasn't from this accident, the photographs made all the importance in the world to her claim. It was the strangest thing I had seen. That attention to detail that she did, we can't do it for you. We're not out at the scene that day, right? We're not going to even know about your wreck until later that day at the very earliest. Most folks call us day after, a couple of days after. We can't go back and take some of these photographs and things, right, to prove that this damage was really caused right there at the scene. And so this saved her a tremendous amount of money, shortened the fight over these things, and it was beautiful for her. So remember, doing these things that only you can do, like take pictures at the scene, are really, really important. Now, this next one's probably the most important, so please listen to all of it because there's some nuance to it, and it is the thing that drives me crazy. It's the number one reason that you're going to get a lowball offer from an insurance company. What is that? It's don't rush your medical treatment, all right? Meaning don't skip any steps. Don't do it, all right? You don't want to let the insurance company rush you through it. Through a quick settlement at the beginning, hey, we'll cover the first 2 weeks of treatment, this, that, and this, or calling you and making you feel like this is taking too long, right? Very big mistake, very common. Okay, so after a car accident, especially if you're feeling okay, for instance, or just sore, I get that a lot when people call, I'm just feeling sore. You might be tempted to just not go. I might not need to go. I'm going to tough it out for the next couple of days, see how it goes. It's very rare that you're just going to all of a sudden be better. Yes, it can happen in your real low impact wrecks, but it's rare. The problem is if you don't, it's going to be a delay the insurance company is going to use against you. Well, Ted, look, they didn't go by ambulance. They didn't go that day to the ER. They waited 3 days. That's not correct. The insurance company's going to say the injuries came from somewhere else in those 3 days. I know it sounds horrible and it's not true. We can fight through it, certainly if it happens, but why give them that argument? Go get checked out. If you're better in 2 or 3 days, which I hope you are, then that's fine. You had one visit. You had one visit to say you were sore and things were hurting, to kind of document things, and then you didn't need anything else. That's perfect. That's okay. But don't turn it into, I didn't go at all, and I had pain for 3 days, but then I was better. You're going to get a lowball offer. They're going to say you didn't get any treatment. So you see how that can really play against you. So get checked out as soon as possible, even if you're feeling fine or just sore, right? It's not unusual in Georgia with whiplash injuries, things like that, concussions, even soft tissue, that you're going to feel fine at the beginning, but in 2 or 3 or 4 days, I've had weeks later, it starts to rear its ugly head. Not uncommon, but you want to have that initial treatment right away. And the next key is follow every instruction from your doctor. Yes, it's your body, it's your choice. So there might be some real unique things where you just don't want to, religious or otherwise, do that specific type of treatment. But the big thing is if they tell you not to lift certain weight, don't. If they tell you don't work, don't work. If they tell you you need physical therapy, go to the physical therapy. If they tell you you need injections, get the injections. You don't do any of these things that the doctor tells you, the other side is absolutely going to use it against you. Well, the doctor said you needed to do physical therapy, you didn't do it. Doctor said don't go to work, but you decided to go anyway. Well, you hurt yourself further at work, not listening to the doctor. It's going to be the argument. That is going to create the soup for them where they can argue for a lowball offer. You didn't follow your doctor's advice. Don't do it. So let me share a real story for you here in Georgia. I had a client, Macon, who was feeling better after a week and decided to skip her follow-up visits with the doctor. When her pain then comes back, because she was feeling good for this little period of time, and then the pain comes back, as it always typically does, a couple of weeks to a month later, the insurance company, and she goes back into treatment, says, no, that's not related. You were feeling better. You skipped the appointment. You had no other treatment. And then a gap of a month, and then you're back. Something happened in that month. This isn't related. This looks weird. And they're going to make it seem like you're lying and everything. So that's what happened to her. And they're saying you failed to mitigate damages. They come up with all kinds of stories. If she'd gone to her appointments, she would have had a much easier path. We had to get in there and really fight. And it took a real long time to correct the insurance company, to show them that argument wasn't going to really work in her case. but she created that mess that she didn't need to create. She told me, yeah, I should have followed up. Yeah, you should have followed up. All right. If the doctor says follow up in 2 weeks, you better follow up in 2 weeks. This is too important to skip. You're not a doctor. Don't play doctor. Oh, I'm better. I'm just not going to go back to physical therapy. I'm better. I'm not going to go to that follow up. You don't know if you're better. Okay. You might be feeling better that day or that week, but you don't know what's going to happen in the future. So please follow all of it. Do the follow-up. Get to these appointments. Do what the doctor says until they release you. Nothing more, nothing less. All right, my next big one is don't give the insurance adjuster for the at-fault party a recorded statement. This is going to happen within hours sometimes, certainly within a day or two. They'll sound friendly. They'll sound like they're here to help you with your claim, build your case, all of this kind of stuff. And they want to get your side of the story. That's all it is. And they want to do a recorded statement. But what they're really trying to do is fish by getting you into a recorded statement within a few hours or day of the wreck for anything that their lawyer or them themselves can use later on to twist what you're saying, take out of context what you might say, and use that to give you a lowball offer. And here's how it typically goes. The adjuster asks if you're okay in this initial call, if you're feeling all right, where's your pain, all of this sort of thing. And you might casually say, I'm feeling fine. Maybe you're in a little shock. You got some adrenaline going, all of that, and you think you are feeling fine. And then they say, we want to do a recorded statement. And then if you say all of this on a recorded call, well, you said you were fine. You were feeling fine. And this was hours or a day after the wreck. Now, all of a sudden, a week or so later, you're needing all this treatment. You got all these big injuries, but I have you in a recorded statement saying you were fine. Therefore, use that and twist that and say that means there's no way you can't not be fine, which we all know is not true, but they've got you in a recorded statement. That's why we're not going to offer you what you're asking for, because this pain had to come from somewhere else because I have you saying you were fine. And a lot of folks don't realize in Georgia, you don't have to give a recorded statement to the at-fault party's insurance. There is no requirement to do it. The only one you have to is your own insurance, okay? Or you lose your policy because you violated the terms of the policy, but you want your lawyer to be involved in that phone call. So you have to say yes to that one, but not on your own. You got time. As long as you do it at some point, you've followed the policy, right? But at fault, you have no obligation to give them a recorded statement. Why? They only want it for themselves to help them, not you. So why would you do it? It's never going to help you to do a recorded statement. So you have every right to say, I want to talk to my attorney, or I'm thinking about hiring an attorney. Let me wait to make that decision, or just flat out, I do not want to do a recorded statement. Thank you very much. The police report will tell you what happened. My medical records will show you what my injuries are. That should give you all the information you need. I do not want to do a recorded statement. There is no reason. There is no law that requires you to say yes. And I've had them do this to some of my clients before they hire me. They'll tell you, they'll sing a song. Oh, well, we got to close the claim if you're not going to do it. Or, you have no right to payment if you're not going to do a recorded call. All of those are lies. If they say that, they are lying to you. So let me give you an example. I had a client in Savannah who had called me right after her accident. The adjuster had already left her 3 voicemails asking for a recorded statement, literally on the voicemail. I need to get a recorded statement from you. Please call me back. Because she waited to talk to me, we were able to prepare and together and make sure she didn't say anything and tell them, look, she's not going to do a recorded statement. Thank you very much, but we'll get you all the information you need. I can, as the lawyer, explain anything that needs explaining. You'll get all the records, but we're not doing a recorded statement. Now, contrast that with another case that I had, and it was a gentleman from Augusta, and he gave a statement too soon. So before he hired me and knew his right to say no, he thought it was okay. And what he ends up saying is he wasn't sure if the other driver ran a red light or not. Well, that's not what the police report said. And they said that this guy ran the red light and he's at fault. But now in a recorded statement, he said, I'm not sure if he did or didn't. Now the insurance company seized on that naturally and said, now there's a dispute because what was on that police report might not be true, because now I got a recorded statement from your client saying he's not sure. That just totally blew up that case. And we had to fight liability for a very, very long time, and something that shouldn't have been fought over. But he didn't know to say, I am not going to give a recorded statement. So tip number 3 is don't talk to the insurance company, and certainly don't give a recorded statement about the details of your accident or your injuries before you talk to an experienced attorney and see if you need to hire one. If you do, then the attorney can handle all of that. If you're going to do it on your own, don't do a recorded statement. You're still going to have to talk to the adjuster, but it won't be in a recorded fashion. So be careful of that. It can really come back to bite you if you don't follow that rule. Okay, the fourth tip, and this one's real crucial for anyone trying to avoid getting lowballed if they're handling it on their own, is to know the real value of your claim before you ever consider accepting an offer. Really, before you even consider negotiating, you got to know the value of your claim. And here's the hard truth. The insurance company's job is not to look out for you. I said this earlier. They are not here to help you. Their job is to pay as little as possible on this claim. Like it or not, that is their job. So how can you know what your claim is really worth in Georgia? It's not just about damages to your car, right? We know that. We're talking injuries. You got to know first, what are all the components of your claim, of your personal injury claim, that builds the value? Well, it is, and I say it's past, present, future for each of these. So here's how this works. Medical expenses. Past, present, if you're still treating, and future, if you need future treatment. All of that is an item of damage. Then you've got lost wages. Past, present, and future. Lost wages. You may have none. You may have all three. All right. Then it is pain and suffering. Past, present, future. Past pain and suffering, if you're still treating and hurt, current. And then project it into the future if you can. How long are you going to be living with this issue? Is it limitations? Is it also pain? Is it both? What's going on? Is it one or the other? Pain and suffering, past, present, future. All that wrapped up. And pain and suffering, by the way, includes loss of enjoyment of life, all of these things, right? That's all part of the pain and suffering. It's not just physical pain. It's not just emotional pain. It's also the things you can't do now that you did later. How your life is not as enjoyable now as it was then. How it won't be going forward. All of that combined. All of it, all these items together combined, it brings the value of your claim. So keep these components in mind so you know the building blocks of the value. Now, let me give you an example. I had a client in Marietta who was offered $6,000 by the insurance company right after her crash, before she talked with us. She almost took it. $6,000 within a day or two. We reviewed her case together, and when we added in her physical therapy, her missed work, her ongoing headaches, her true claim value was well over $40,000. And here she was about to take $6,000. So without digging into the details, she would have left tens of thousands of dollars on the table had she not called us, and we went through everything with her and were able to show what the difference in the value was. So don't trust insurance companies to value your claim for you, because they're not here to do that. Take the time, know all of the different items that add up to your value, gather all your bills, your documents, lost wages, all of it. Keep track of how it's affected your life, all of this. And most importantly, you want to talk to someone who can give you an honest opinion about what your case could potentially be worth in Georgia. Talk to an attorney. They can, as part of a free consultation, tell you, this is with what you're giving us. Here's kind of the range of what I would generally say without looking at it in grave detail. I do that a lot with people because I want to give them the understanding of, do you need to hire me or not? Now, she needed to hire me, right? The example I gave you from Marietta, because $6,000 to $40,000 is a big difference. And so she needed us to get in there, giving her that valuation to get it from the insurance company. It was going to be too much for her to negotiate on her own, because they were still going to try to lowball her without an attorney. But this at least will help you in that process. Okay, my last tip, and it's maybe the most important one, for a lot of people it is to get legal help early. If you're going to do it early. Insurance companies in Georgia are very good at what they do. They have experienced professionals trained to minimize your payout. That's their job. If you try to handle it on your own, you're taking a huge risk. Now, you can do that, but you got to know you're taking a risk. A lot of people worry that hiring an attorney will cost them too much, but I get that. Yes, sometimes it's not going to be worth it to hire an attorney, but most personal injury lawyers in Georgia, including my firm, we work on contingency fees, number one. And number two, we can tell you, is this a case that's going to be worth it to hire an attorney? Okay, so we don't get paid unless and until you win your case, and then it's a percentage of what you win. So you're never going to be over your skis where you owe more to your attorney than you do for what you received, right? That you're going to have to pay them out of pocket. We do better when you do better is the concept. So realize it's already kind of baked in that way to help you. There's no upfront cost. You're not paying retainers, any of that. In Georgia, insurance companies know which attorneys are willing to take cases all the way to trial. I talk about this in a lot of my videos. It is so important. Your best chance to not have to file a lawsuit or try your case is to hire an attorney that does that, a trial lawyer. That gives you the best chance to get the most compensation possible as quickly as possible and hopefully avoiding lawsuits or trials. That is a real big key. And I see it time and time again. Clients, they'll start with an attorney and they'll end up with less stress and all of that. And that's great. But sometimes it doesn't work that way, right? And they get concerned and they hear these stories out there and all that. But let me give you an example. I had a client from Columbus. They tried to handle their case on their own, all right, for months and months and months. And understandably, they're trying to save money. The insurer offered them $3,000. That was it, all right? They then were forced to hire us. And we settled the case within a month for $18,000. So it wasn't a massive case, but we still took it because we wanted to help them. We saw that they were being lowballed. And we're like, this is insane. You're talking 4, 5, 6 times what they're offering you is a very reasonable offer. And they were very reasonable people. And so they hired us and we got them that much more. So $18,000 versus $3,000. It's well worth hiring an attorney. Even when we take our fee out of the 18, they came out way above what they would have without an attorney at $3,000. So you can see how having an attorney involved 9 times out of 10 is going to create way more value than what you're paying for. And that's the whole point. We want to be bringing that value. So you don't want to wait to determine, is your case the type that an attorney can help? If they're like me, and hopefully you call me, but if they're like me, they're going to give you the honest advice. Hey, I don't think this one's big enough, like the one I just gave you. I don't think I can do that whole 3 to 18 in your particular case because of what you're telling me. And I think you're better off just settling it on your own. You're going to get less than we will, but the fee, it doesn't fit. It's rare, but we tell people this often, quite frankly. I mean, it's still rare given the numbers of folks that we talk to, but we're open with that. We want to bring value. And oftentimes the value's there, but you want to have that conversation early. Don't wait. So there you have it. The 5 tips to stop insurance companies from lowballing you after a car accident in Georgia. And let's recap. What are they? Number 1, gather all the evidence, every single bit that you can from day 1. Second one, really, right there at the scene. Number 2, don't rush your treatment. Don't skip medical treatment. So don't rush through it and don't skip. Don't be your own doctor. Follow doctor's advice. 3, never give a recorded statement to the other party's insurance without legal advice first. And don't do it for yours either without legal advice. You got to do it to yours, but get legal advice first. And number 4, you got to know the value of your claim, which starts with knowing every component of damages that equal the value of your claim. And 5, get legal help early. At least have a conversation with a Georgia personal injury attorney. And more likely than not, you're going to want to hire one. But have that conversation. Know if you need to hire them and do it early. Don't wait weeks, months, and years to do it. If you follow these tips, you'll have a much better shot at getting every dollar of compensation you deserve and protecting your rights. But what happens next? You might be wondering. Will my car accident lawsuit go to trial? That's a huge question in Georgia. I get it all the time. And there are things that you can do right now to avoid getting dragged into court in a trial. My next video breaks down step by step when it goes to trial and when it doesn't. So you don't want to miss it. It could save you months of worry and help you get your life back faster. Click over to Will My Car Accident Lawsuit Go to Trial right now to make sure you're ready for whatever comes next. See you over there.